guys, how you doing? Bill Demas here with Curse of Knowledge podcast from Herman Wells. I am flying solo today. Warren's not here. You guys can get on him later for missing another video, Warren. I'm here today with a really special guest, a really good friend of mine, Vanessa King. She is a criminal defense attorney. She is also in the leadership of the Pinellas County trial lawyers. She's an excellent attorney. She's an excellent trial attorney. We really learn a lot from her when we sit around and we talk. But we're talking here today about criminal law stuff. I want to start and say thank you for being here, Vanessa.
Of course, thanks for thinking of me.
We ask a couple basic questions when we start, and then we're going to get into the meat of it. Basically, just a real quick, where were you born?
I was born in Miami, Florida.
Okay, and did you grow up in Miami?
I grew up in a very small town in Central Florida called Inverness, home of the Cooter Festival.
I know Inverness well. Okay, yes. So where did you go to high school?
Citrus High School in Citrus County, Florida. Yep.
And college?
UCF.
Awesome. And law school?
Florida Coastal School of Law.
Awesome. So what was your first real adult job?
My first adult job was a restaurant manager at Smoky Bones in Orlando.
Nice. Mm-hmm. And before you were a lawyer, what other type of jobs did you do?
Before I went to law school, I was always in the hospitality industry, bartender, server, and then management, but always restaurant, and yeah.
What lessons did you learn from the hospitality industry? Because that was my background too. I know what they are, but tell the folks at home that translate to being a lawyer and help you be a better lawyer?
That is a great question, and I've gotten it a few times because first day of law school, we're going around the room and everyone's background in criminology, political science, and I'm like, hospitality. Hospitality, in my opinion, gives us a better understanding of how to deal with people. I get this a lot, that a lot of attorneys can be very awkward, especially transactional attorneys.
Right.
And I think being in the hospitality industry has definitely helped me with the people aspect of it. And when it comes to client relations and kind of trying to get people in the door and wanting to go with me as opposed to the competition.
And let's just break it down. There are no bones about it. And that's not a...
You bones joke?
Yeah, that's not a fun joke. You know, like that. I'm a disability and first party insurance attorney. So people come to me when they're disabled, when their house and their roof got blown off by a hurricane, they got in a car accident. Worst moments of their lives. You get people when them and their loved ones are being threatened with losing their freedom. So we see people at some of the worst times in their lives. Mm-hmm. And I find that hospitality background helps me deal with that and not, as you said, some of these real awkward attorneys that they just don't know how to deal with somebody that, you know what, when you were a server and the food's not right, they're not mad at you, they're mad that their food's not right. So you're taking the brunt for the kitchen. Back of the house never gets yelled at. It always gets yelled at. Mm-hmm. So you just learn to go, oh, okay, gotcha, understand 100%. And that right there, that's helped me guide a lot of people through.
Right.
Because it's the empathy. Yeah, I get it, understand, it's tough. And you realize that they're not mad at you, you're on the tracks when the train's coming through.
Mm-hmm. Yeah.
And you need to be able to go, okay, boom, and move on. So, we're gonna go back to some of your attorney stuff, but we're moving the lightning round to the beginning because I think it's fun, okay? What is your favorite pastime or hobby?
Favorite pastime or hobby? I love to travel.
Okay.
My happy place is a tropical island with a boat drink in my hand, listening to some reggae music.
Well, drinking both hands?
Potentially.
Okay.
Yeah, that sounds pretty appealing.
Favorite flavor of ice cream?
Rocky Road.
Favorite movie?
Dirty Dancing.
Your opinion of what is the best sitcom of all time?
Ooh, that's a really tough one. Crazy Ex-Girlfriend. I don't know if you've seen that, but that's a surprising, hilarious show. But Seinfeld, some of the classics, Friends, things like that.
Coke or Pepsi?
Definitely Coke. Interesting. I like Diet Coke, but I like regular Pepsi. I don't like Diet Pepsi or regular Coke. Yeah. But Diet Coke is what I would go with. Yeah.
Starbucks or Dunkin' for your coffee?
Oh, Dunkin' all day long. Starbucks is like that funk.
Are people that go to the beach and sit directly on the sand without a towel or a chair, do they have something wrong with them or they're okay?
I think something's wrong with them.
Thank you. See, I put this question in, guys, because my wife of 25 years will get out of the water for this day and sit right on the sand wet. And I'm like, you're a sugar cookie.
Yeah, no, the feel of it.
Yeah.
I get the toes in the sand, the feet in the sand, but I don't want my butt in the sand, no.
Ketchup on eggs or no?
Oh, no. Hot sauce, yes.
Thin or thick crust pizza?
God, that's really tough because I like both. And you can't go wrong with pizza, in my opinion. But I'd go thin, on like a New York style.
Yeah.
Yeah.
Do you like candy corn?
No. Oh,
Okay. Are you an early bird or a night?
crazy early.
Do you like the chicken flapper or the drumming for chicken wings?
Oh, drumming. Yeah. Well done, drumming.
Corner of a brownie or center brownie?
Corner.
What is your death row meal? Meaning that last meal on the face of the earth, what are you eating?
Okay, this is gonna sound crazy. It's a salad. Okay, I have to explain.
Thank you, folks, for tuning in. I don't want to hear another thing out of her. We're going to go home.
No, I have to explain this.
Okay.
All my friends who know me well know about this salad. It's called the hangover salad. Started it in college. It is not a healthy salad. I actually started it when I worked at Smoky Bones. Shredded lettuce, bacon, tomatoes, shredded cheese, black olives, like fried chicken with buffalo sauce and ranch and hot sauce. It's like the most unhealthy salad ever in the world, but it's delicious.
So basically that is, if you flip it upside down, it's basically smothered fried chicken with shredded lettuce on it.
Pretty much.
Okay, so it's not a salad.
Yeah,
Okay.
it's not a salad.
Desert Island album. You're stuck on an island and you have one album to listen to over and over again.
George Michael Faye.
That's why I love this podcast. The person that's either currently alive or from history, and I think I know who this is because I know you, that you would want to sit down and talk to and have a beer with.
I love George Michael, but Ruth Bader Ginsburg, you knew
I knew it. I mean, I knew it was
my
coming.
dog's name is Ruthie Bader Ginsburg.
Yeah. Artist or group that's no longer touring that you wish you would have seen when they were touring.
I was gonna say, I luckily saw Jimmy Buffett before he passed, and George Michael while he was alive as well. Oh, that's really tough. Oh, I did really enjoy, my husband is a huge fan of, oh my God, it's gonna drive me crazy. AT Aliens, Sorry Miss Jackson, why am I going blank on this group?
Okay. Yes.
But they disbanded early hip hop from, oh my gosh, what
Yes,
are they called?
I know.
Outcast.
Outcast.
I
Yes.
would like them to see Outcast before they split up.
Your first celebrity crush.
George Michael.
Okay, there you go.
Unfortunately, I found out I wasn't his type, but
Well, yeah.
George, all day.
Favorite city in the world that you would want to live in if you didn't live here?
Visit or live in?
Live in.
City, or you said in the world?
City.
City. I loved San Francisco, like California. I have not been overseas since I was younger. I am going to France in a couple months. I would say places I have been to, cities. I'd say San Francisco. It's so pretty. It's like Florida, but with mountains and more scenery.
Also, on your question, would you rather be able to speak every language or talk to animals?
Because I am a realist and I feel like it would be more beneficial being able to speak every language. So I'd go with that one.
But sometimes you look at your dog and say, I would really want to know what you're thinking right now.
I don't
Yeah.
Yeah.
All right. When you got out of law school, what was your first job as an attorney?
I worked as a prosecutor at the state attorney's office in Jacksonville.
Okay, so how many years did you prosecute for the state?
3.5. I transferred, so I was in Hillsborough for a short period of time before going private as well.
And then when did you open up your own firm?
6 years ago, in August, it'll be 6.
Okay. And do criminal defense?
Personal injury.
And personal injury, yeah. And you do it, you're a rarity because you do both state and federal cases.
I do.
Can you explain the difference for them? What's the difference between the state and the federal is?
Yeah, with federal, it's going to be if it's regarding crossing state lines, a federal offense, so post office has to do with post office. In the criminal realm, a lot of the types of cases I handle are if a conspiracy or something cross state lines. Let's say I have a client involved in a drug conspiracy and it was pills, but they were able to show that the pills came from a different state, or if he was in possession of a firearm and those bullets were from processed or manufactured in a different state, that could make it federal as well. Some crimes can be tried in both state and federal courts, but federal court is going to have jurisdiction to federal crimes committed on federal property, and again, when it crosses state lines, those drug conspiracies, but some of those drug conspiracies or drug cases can be tried in state court as well.
Interesting. And I've never done criminal law, something I've just never done in my career. We both know a lot of people that do it. And one of the most interesting things was an old time attorney was telling me the story when he was young, he got on the federal court appointed list and he was representing a 17-year-old kid that was down here in St. Pete that some guy came around and tried to say, here's $200 and you see any cops, write down and tell us. And I guess it was a sting and they all got busted. And this 17-year-old kid that just took $100 to sit on his bike, they were charging him with this high level as a conspirator in this high level drug. And the kid was, I'm just there. Did that still go on?
So you're saying a smaller role being tied up in a much bigger drug conspiracy. So that's the thing with federal court. Conspiracy is the charge that they typically charge. And it's basically the crime of one is the crime of others. So if they can show two or more people work together to achieve a common criminal plan or goal, knowing what was going on, even though that kid might have had a minimal role, if he knew about it and he was involved with it, conspiracy. And that's really how people get lit up in federal court a lot of the time.
That's just scary. It's so funny. One of my pet peeves, and people still use it, judges still use it. The statute says co-conspirator. And I argue with people all the time. This is every conspirator is a co-conspirator because you need more than one. You can't have a single conspirator. And law, a lot of things, like when they say joint stipulation, a stipulation can't be
just one-sided.
It has to be joint.
Yeah, that is true.
The parties filed this joint stipulation. The parties are filing a stipulation. That's great. Anyways, more than you guys do now. All right. So this podcast is called Curse of Knowledge, and what we try to do is talk about what practitioners like you do, but also some of the misconceptions, the curse of knowledge that your clients have when they walk in the door. So you're a criminal attorney. I can imagine what preconceived notions your clients have when they come in because they've watched so much TV or Blue Bloods or Hill Street Blues or Law and Order or CSI. But what's some of the biggest misconceptions that you have to tell your clients, no, that's not really a real thing?
Oh yeah. I love when people say hearsay. Oh, that's hearsay. No, I heard this. It's hearsay. It's hearsay. Hearsay is confusing to attorneys who have been practicing it a long time. Half the time they say hearsay, it's not hearsay, or they're misinformed as to what that means. But no, oftentimes people see these shows. The camera's there, right? Not here. Okay. People see these shows. I just want to make sure I'm looking in the right direction. People see these shows and they see within an hour episode, someone's arrested for murder, first degree, and they're going to trial in 2 weeks. So as far as the process and the time it takes, I think there's definitely misconceptions there. What evidence is actual evidence? And you see the fingerprints, the DNA, all of these types of evidence, eyewitness, surveillance, and they're like, oh, well, you have to have this. They don't have it on video. Obviously, they can't charge me with that if they don't have specific types of evidence. What people don't understand is there's circumstantial evidence. A person testifying is evidence, right? If a jury finds them credible and they believe what they're saying, that can get you convicted, right? Yeah, I think the misconceptions with people are expecting DNA, video evidence, and all these types of
The CSI effect.
Exactly, the CSI effect, which rarely there's going to be that. And they're alleging somebody handled the gun, but there's no fingerprints, there's no DNA. Just because somebody touches something doesn't mean it's going to leave DNA. But yeah, I think that's definitely something I deal with a lot, especially in the federal cases. It's harder because a lot of the time in federal cases, there are cooperators and people are implicating other people to get a better resolution for themselves. And I've had cases where it's going to be 6 people with a criminal history that are pointing to you saying you did it, but if a jury believes it, this is what you face based on what you can control if you were to plead. So those are the tough conversations, trying to get a client to understand that. But yeah.
How about the misconception, and you see it on TV all the time? You have to tell me if you're a cop. I'm going to sell you drugs. I'm asking you. You have to tell me.
You can just ask my client charged with solicitation of prostitution if that's true. That is not true. Officers can use deceptive practices.
And it's not a trap.
It's not. Entrapment is a very hard defense to show because basically if an undercover officer is basically laying the foundation, giving somebody the opportunity to commit a crime and they act on that, it's not entrapment. Yeah, entrapment's one I hear all the time, especially in a solicitation and prostitution charge. I was entrapped. No, because they put it out there, but then you asked or offered or said you pay a certain amount for a certain thing.
Now, there are also some, because how many trials have you had?
I've had over 35 jury trials and a bunch of non-jury trials.
So you've picked 35 juries?
Me or my co-counsel.
Yeah.
Been involved with the big jury.
What are some, in the criminal world, what are some misconceptions or curses of knowledge that jurors have that you have to, that you know, if you go pick a jury tomorrow, you have to ask these questions because most of the people on the jury have this misconception about the charge or about the system?
That's a good question. I will say this, when it comes to picking a jury, the questions I ask are going to be specific to the charge and that defendant. I'll give you an example. I had a case recently where based on the charge and our defenses, yeah, I was looking for jurors that were younger males, and I was trying to eliminate some females based on what I perceived to be our best chance. But one thing I think that juries are misinformed about is they think that they're determining someone's fate as far as what they're going to be sentenced to, and I can't be responsible for putting somebody away for life or for sentencing, because that's, some people get involved with religious beliefs or whatnot. But I think the judge is the one who will ultimately sentence somebody if they're convicted. The jury's responsibility is to listen to the evidence and determine whether the elements were met and whether that person is guilty or not guilty, and then it will be up to the judge to sentence.
And is that even on death penalty cases, or does the jury need to recommend?
That's a great question, and I know the law's changed in the last few years with regard to consensus and amount of jurors and all of those things. I am not death qualified, so I'm not necessarily up to,
Again, this is why we call it podcast Curse of Knowledge. You just said death qualified, which I understand. Can you explain that to them?
Yeah, so in order to try death penalty cases, there are certain requirements of an attorney that they have to meet before they can be qualified to handle cases, defensive defendants, where the state is seeking the death penalty, and I have not received that certification.
Another misconception is like all these movies where Matthew McConaughey is just out of law school and he gets tapped to try a murder trial. That would never happen in the state of Florida because the state wants to make sure that the person representing you is qualified and you just didn't go get the cheapest person right out of law school.
That is my understanding, maybe with a co-counsel who's qualified, but yes, solo, I do not believe that is allowed.
And by the way, folks, it shouldn't. That's somebody's life.
Right.
And you really shouldn't trust your freedom on who's going to charge you less, because you have to look at their qualifications. You have to get somebody like Vanessa or somebody like that. And here's the great thing about Vanessa. You're watching this and you're like, oh yeah, my cousin has this and my buddy has that. Have them reach out to Vanessa, because she'll be the first one to say, yeah, you know what? I don't handle cases like that, or I'm not death qualified, or I'm not really interested in something that, but here's Dennis Fleming. We can tell you tons of attorneys. Not only you can look up their credentials and see massive cases that they've won for these big cases, but are nice, honest people. Mm-hmm. The one thing I always tell you guys is use us as a resource. Call us first, because if she's not able to handle your criminal matter, she's going to get you to somebody that has done it 50, 100 times before, and that you can search Google and their name is going to pop up, and they're salt of the earth people that aren't going to just sell you down the river for money.
For sure, yeah.
So if you call us first, we can be your conduit for this. But it may be something that Vanessa can handle, but the great thing about her is she just told you that she's not qualified to handle something. She's going to be honest about it. That's why you call her, because you don't want somebody to say, oh yeah, I can do it, and then they get down the road and they're underwater.
And unfortunately, we've both seen that happen. So I've been practicing 13 years now, and I know I stay in my lane.
I make the joke a lot of times is there's a type of disability that veterans get. It's called VA disability. And I know a lot of friends that did it, and I was at firms that did it. And I know enough to have a conversation with somebody, but when they say, hey, Bill, can you handle my VA disability? I joke around and say, I can't spell VA. I don't want it because I could probably muddle through it, but I've been practicing for 25 years. I'm not going to muddle through something. I'm going to say, hey, call this person. That's what they do. If you get a disability claim, you're not going to try to muddle through it. You're going to send them to me because they're going to get good representation. So use us as tools. Now, what have you seen of some new changes? Because Governor DeSantis has changed a lot of laws recently when it comes to in the criminal side. We were at a meeting. We're both members of the Pinellas County Trial Lawyers. She's one of the leadership. She does an awesome job leading the organization. And we had Sheriff Gutierrez come in and talk to us. And he was talking about a slew of changes that were happening that, I don't know about you, I was sitting back going, I didn't know that law even passed.
Yeah.
So what do you think are some laws that have potential impacts on your clients or potential clients that they probably don't even know that passed recently?
So today I was in court, and it was my second court hearing on this case. And typically there's a process. You have your first appearance where you enter a plea of guilty, not guilty. You don't know much about the case, if anything, other than what your clients told you and the arrest affidavit with general information. And there's a whole process to get the evidence, and there may be surveillance, and it's a process to get that. Today, it was my second hearing on this case, and the judge said by the next court date, we need to know which way it's going, if we're going to resolve it or set it for trial, because law changes coming where with misdemeanor cases, I think judges putting some pressure on moving cases along quicker. I don't know specifically, honestly, what law she's talking about, to be honest with you. That happened today, but it's definitely something that's going to affect criminal defense lawyers, especially when, and not necessarily in a good way, when we're relying on the prosecution and the prosecutors to provide that evidence that they plan to use against our client. So sometimes our hands are tied and we can't do anything any more quickly.
And that to me is baffling. I understand the governor passed a law that, and then the Supreme Court made a recommendation that for civil trial cases in state, they can't drag anymore 18 months from the time they file to the time that you're trying cases. I get that. It's a civil case. But when you're dealing with somebody's freedom. Now, what I want you to do real quick, because everybody at home is sitting, but hold on. Why is that a bad thing? Isn't there a law called speedy trial, that in criminal law, that you can't drag these people along because they're sitting in jail? Can you explain speedy trial and why a criminal defense attorney like you would waive speedy trial?
And even if a client demands speedy trial, if an attorney believes it's in their best interest to override that, we can.
Oh, so you can override it without your client's consent?
Yes, it's not advised. I don't want to do that. I want my client to be fully informed and understand. But if I'm not prepared for trial, for instance, because there's certain evidence missing, even though my client wants a trial, or whatever it may be, yes, I can make that decision. But speedy trial, everybody has a right for the state to be tried within a certain amount of time. On a felony, it's 175 days. On a misdemeanor, it's 90 days. And even if somebody weighs up, but getting back to your point, why would I recommend waiving that right? Because we don't have all the evidence, right? Depositions are outstanding. Somebody is facing serious time in prison, and it's going to potentially be beneficial on a felony charge to hear what those individuals are going to say under oath, right?
Yeah. So something happens. We're in St. Pete. Something happens down Mirror Lake, which is just the lake downtown, right outside City Hall. And there's 10 witnesses, and who your client swears are going to clear him because he wasn't the guy that started it. You got to hire an investigator to go find those 10 witnesses. And a lot of times those witnesses don't want to be found.
Yes.
Because they don't want to be involved.
Exactly. It's very true.
So you recommend to your client, listen, we got to find these people.
Exactly. If there's evidence, and it just takes time to coordinate schedules with busy prosecutors in order to accomplish and be as thorough as we can to get the best possible defense. Waiving that right is important. However, at any time, we can always demand speedy trial. Even if we waive it, we can demand it again. And then there are certain time parameters in which that case needs to be tried.
Very interesting. Now, the law changed in the state of Florida, and Sheriff Gutierrez talked about it, that you don't need a concealed weapons permit anymore. It's been about a year now, concealed carry. If you're eligible to carry a gun, you can carry a concealed weapon in the same places you were able to carry if you were licensed. So you can't have it at the bar, you can't have it at the buckskin, you can't take it to the trial.
Yeah.
Or if you have a sign outside that says no weapons, they can't bring a weapon into your place because it's your control. Have you gotten any cases or heard of any cases of where people are getting in trouble because of that new law?
Surprisingly, no. I haven't.
And the sheriff said that really surprised me.
It surprises me too, but because it doesn't, like we had talked about with the sheriff, just because laws in place now doesn't mean anyone can sell a gun, right? They have to have the people that are able to get their concealed may qualify, but it doesn't just mean anybody can have a gun. Convicted felons still can't be in possession of firearms. But no, I personally have not seen the state, at least here in Pinellas County or Hillsborough for that matter, prosecuting.
And I've asked a bunch of people, and they haven't either, which, folks, it's not like we're mad about it. But as a practitioner, when you see a law sometimes, you go, how's that really going to work out?
Yeah.
And in my mind, it was like, I was never shocked that up until the recent case that John Trina was talking about, where he represented the guy that pulled out the gun at the quick stop because he was threatened to stand your ground. Before that, I really hadn't heard of a person that got in trouble with their concealed weapons or took their gun out and did something with it. So I always thought that the state did a very good job monitoring the people that got it. And in my mind, now you're taking away that regulation. Maybe some other people that don't have the impulse control and couldn't pass the background checks are now going to have them, but it doesn't seem like that's been a problem, which is good.
Yeah, I don't know. Definitely still seeing a lot of convicted felons with firearm. They're still going forward on those. But yes, I haven't seen that.
And then to be clear, with this law, you're only able to carry if the law allows you to carry. So just because they changed the law doesn't mean that you can be a 6-pack in and put your gun on you and start running around town. Intoxicated people aren't allowed to have even a concealed weapons permit.
Right.
You can't drink and carry your gun.
And there's no open carrying. So you still can't have a holster like cowboy style. And
Right.
Can't do that.
Yeah, it's not open. Which surprisingly that the sheriff was against open carry.
I know.
And I, not that it surprised me, but I would think, I don't know what the difference is. Maybe I'm not sophisticated enough, but he was very measured in saying, we really don't like that because X, Y, Z. And I thought that was very interesting. And that's another great thing about organizations like the Pinellas County Trial Order that she's on leadership of is it gets attorneys like us to talk to the sheriff, to talk to other people that dissuade our misconceptions. Because even as attorneys, we have the curse of knowledge.
No, and that's true because with that, for instance, we have to get, especially clients of mine that are in jail, I have to get them their evidence so they can review it. But we think on the defense bar that maybe he's just being a jerk or whatever. They're putting these requirements, making it harder for us. But being able to have them at a meeting and talk about like why they're doing things a certain way because of some of the issues with drugs getting into the jail, it makes sense, and it was helpful, I think, for a lot of us to hear that.
And that's a good other question to ask you. You were talking about the process, their arraignment, and then this and that. Let's talk about between that. Your client gets arrested, and before the arraignment, and they can't post bail either because of financial or just because there is no bail. How do you visit that person?
Thankfully, Pinellas and Hillsborough counties both, they have video, and Pasco County for that matter, have video visitation, which has been great. That started being implemented during COVID, and it's continued on, thank goodness, because going to the jail takes out a huge chunk of time. But I'm also but you asked pre-arraignment. Right now I am preparing for a trial coming up this next month, and my client's in custody. And I'll do video visits, and then I do go still in person and visit him in jail as well.
And with the video visit, as well as the in-person visit, that's protected by attorney-client.
Absolutely.
So the state can't record it, can't listen in.
They better not be.
Right. I just want to say that because some people don't trust
Right.
the system, but that is one of the things that I've never heard of the state violate. It's such some inner sanctum thing, that attorney-client privilege, is that they may fluff around in a lot of things, but they never really fluff around with that.
They shouldn't. And sometimes, a couple things with regard to that. If a third party is called, my client is on the phone with girlfriend calls me, that's not privileged anymore, right? They're violating that privilege. And my client, if he's calling me like that, hey, this is not a confidential conversation anymore. And there have been times where my client will call me and maybe it says this will be recorded, and for whatever reason, it doesn't have that attorney-client privilege language in there. I always say, hey, if anybody's listening, this is attorney-client privilege information, to put it on there. I have not run into an issue where that has been violated. I think the prosecutors here take that very seriously and understand how important that privilege is to preserve.
Yeah, and I had a client that every time he sent me an email, he went on the web and found this blurb about, this is protected under attorney-client privilege. I don't authorize disclosure of this. And I find that you don't have to put that on it. Our emails are attorney-client privilege, and if that's just to remind you not to disclose it, and I was like,
thank you for reminding me. How long have you been practicing, Bill?
Yeah, thank you for reminding me of my ethical duty not to violate it. But that's something that you guys really have to, at home, really have to realize, is that their attorney-client privilege is super important. And a lot of times, it's not us that mess it up, it's our client. How do they mess it up? She's talking to her client, and they're having a conversation, and she's at the nail salon talking to where everybody can hear, and have you on FaceTime or speaker, and you don't know it. People don't put the phone to their ears anymore. I don't know. And they're sitting in the nail salon, or they're sitting in the barbershop, or they're sitting with their boys. That conversation is now waived.
Right.
And even if the other party, even if the third party only hears their portion, it's waived. So you guys have to realize at home, if you call me or Vanessa or your attorney, and you're sitting there talking When there's somebody that's not your spouse in the room, okay, you've waived attorney-client privilege, even if they're only hearing one side of the conversation.
Another thing along those lines too is I'll have somebody who actually pays my fee who is not the client.
Next question.
Yep.
Awesome.
And I always tell them from the beginning, for an example, client's 18 years old, but mom and dad are paying their bill. I make it crystal clear to mom and dad, hey, you might be paying my bill. I appreciate that. However, I'm not sharing it for any with you. Your son is an adult. If he gives me permission to share certain things, I can do that, but he is my client. And I'm not going to fill you in on anything without his permission.
I have that in my disability cases where there's a husband and wife, and because one of them is disabled, one of them is the forefront.
Mm-hmm.
And I hate to say it, but the worst are the guys. When the wife's disabled and it's the guy, and he's calling me up, I'm like, look, you need to get your wife on the phone. I can't tell you this. Women will always go, okay, Bill, no problem. Guys want to get all, it's my wife. I'm like, yeah, I know, but she's my client.
Exactly. Yeah.
And I get around that as I have them sign a limited power of attorney. Yeah, because if the wife has a TBI, I really need her to have another set of ears because she can't process what I'm saying.
For the listeners, what's a TBI, Bill?
Traumatic brain injury. But you probably get that too when you get somebody, and unfortunately, a lot of people that get in trouble with the law, not a lot of people, but a good portion, they're in trouble with the law because there's something else wrong. They have mental illness, low IQ, something, and then you're trying to explain massive life repercussions to them.
Yes.
Sometimes it's good to have somebody sign that limited power of attorney so you can say, okay, mom, if he does this, he goes to jail for a really long time. But if he signs this, he gets probation. You probably, because you want somebody there to help you with that sometimes, don't you?
Absolutely. Yes. And then I am fortunate to have a great paralegal, and she's part of the firm. She's under that privilege that all of this is confidential, and her assistance too in some of those types of cases is helpful.
Yeah. So guys, when you call in, anybody associated with the firm is under that umbrella. So you just don't always have to call the attorney. They're all locked in under that. You've been practicing 13 years, okay? What is your weirdest case that you either prosecuted or defended?
Weirdest. My goodness. I've had some interesting ones over the years. Weirdest. I'm trying to think. I remember some things where it was like, I remember I had to say on the record that the defendant hid something in his butt crack, like saying that on a factual basis, like silly things like that. Weirdest case. Let me ponder that one. I'm going to have to come back on that. I've got a lot of good stories, and of course, putting me on the spot, I can't think of the weirdest.
Because like Alan Gustafson, who is an attorney at our office doing our construction law, but was a prosecutor in Polk County, says that his weirdest one was this guy that kept on climbing over the fence. Apparently there's an alligator preserve out there, and swimming naked with alligators.
Oh my gosh.
And he had lost like a hand and a foot, something like that, and he kept on. They kept on prosecuting him, and he kept on getting out and doing it until it eventually killed him.
Yeah.
But he was like, "You're prosecuting the guy. You're looking at him, going, Your Honor, this is going to solve itself eventually."
Yeah, that's definitely going to solve itself.
So
I dealt with some individuals with interesting beliefs. I don't know, sovereign citizens. When I was a prosecutor, those were challenging cases just because you couldn't rationalize with them. But I'm trying to think. I can't think of anything strange. Yeah, let me keep pondering.
In your practice, what is your range of criminal cases that you take?
That I thought of an interesting case.
So let's get back to the interesting case first.
I had a client who was hallucinating after severe dehydration and alleged drug use at a music festival, and his behavior was extremely odd without getting into details that may give away client. That was a very strange set of circumstances and actions.
Well, music festival, drugs, dehydration, you can all imagine. What
happened
there. So what is the range of cases that you would that you do handle here?
Yes. I typically don't take traffic. The reason I say that is because a lot of people that handle only citations, speeding, running stop signs, things like that, there's a volume practice. So typically they do a lot of them because you don't want to pay me my hourly rate or whatever my fee would be to just handle that. However, if somebody gets a DUI, with a speeding citation that goes along with it, I'm going to handle both of those and resolve the speeding with the DUI case. But any misdemeanors, anything from domestic batteries, possession of marijuana, if they still charge with that, if someone doesn't have their medical, they have decriminalized that, which is great for the other individuals that don't have medical cards. Resisting without violence, any misdemeanor charge you can think of is something that I would handle. Felonies, gun possession charges, drug charges. I've handled everything from a misdemeanor assault to attempted murder and murder charges as well when I was a prosecutor. With the federal cases, wire fraud, money laundering, any those types of transactions, as well as drug conspiracies. It's a Hobbs Act robbery. That's what they call a robbery at federal court, but violent crimes as well. In federal court, some robberies, they keep there, and it's because currency is taken, and obviously currency is used statewide or across the state line, so that's how they get it in federal court. But yeah, basically any federal charge that comes up, that's going to be a good case for me that I would handle. And then any criminal charge and investigation, something that is really important. A lot of people will get a card from a detective investigating something, and if you were to call an attorney at that phase, it's only going to make your life easier. There have been times where I was able to defer.
Let's talk about that. Somebody is out, something happens. A couple days later, there's a knock on the door. There's an investigating detective from one of the agencies or officer or deputy. They say, hey, we just want to ask you a couple of questions. What do you suggest people do?
Depends. The quintessential attorney answer, right? What happened that few days prior? Had some drinks and they hit a car and they took off and they knew that occurred, right? Then I advise you not talk. Say, I respectfully have an attorney and give me a call. This is another thing too. A lot of the times officers will start asking questions that they already know the answers to, and their decision might already be made to arrest a person, and people will talk thinking they're helping themselves. But in a criminal case specifically, you hear the defendants have a right to remain silent, and that's so important because anything I say can't be used against a defendant. Anything a defendant says or an arrested person says can be used against them. So if people mess up, if somebody did something wrong, I advise spend a night in jail. Don't talk, be respectful, call me in the morning. Bond out, call me in the morning.
Okay.
Yeah.
Even if they say, hey, we can talk here, we can talk at the station, that whole thing maybe hear all the time.
Yeah, as I mentioned, they can use this to practices a lot of the time. I'll give you an example of when a lot of people think they're helping themselves and they aren't, in my opinion, in a DUI investigation, right? Officers will say, help me dispel my suspicion that you're under the influence by doing field sobriety tests, right? Or they'll ask them questions and try to get them talking so they can say their slurred speech and bloodshot watery eyes. There's these buzzwords. But with the field sobriety exercises, I've reviewed hundreds, if not thousands of videos on both sides. Nobody passes these tests. People are nervous, law enforcement's around. Sober, it's hard to pass these tests, right? They're divided attention exercises with people that are a super stressful situation. And in my opinion, a lot of the time, people are giving the state evidence to use against them by participating, but law enforcement will make individuals feel like they are helping themselves by doing it, and usually they are not, in my experience.
So what is the consequence if somebody gets pulled over, they've known they have a couple, and they know they're probably going to fail things, or they just don't trust the system, and they just shake their head and go, no, I'm not blowing, I'm not doing the tests, what's the consequence of that?
They'll get arrested, right? They will get arrested. If law enforcement believes that they've seen signs of impairment, whether it's a driving pattern, they see bloodshot watery eyes, odor of alcoholic beverages coming from your mouth, getting stronger as we speak. Those are some of the things they will say. You have it. Most likely, if they've said those things, they've made up their mind and they're arresting you regardless of what you do. So speaking minimally, being polite and respectful, understanding you're going to spend a night in jail, and then call me in the morning. That's the thing. You can refuse. You have that right. They will read you what's called implied consent, meaning driving is a privilege. It's on your driver's license. If you look at it right now, it says that by having a valid Florida driver's license, you are consenting to perform a sobriety test if suspected of driving under the influence. And if you don't do that, you do potentially face driver's license suspension. However, in Florida, if it's a first-time DUI, you can get an immediate hardship. So it doesn't necessarily mean if you refuse field sobriety tests and refuse breath that you're going to lose your license.
Okay. as we wrap up here, what are some other things that if now that you have a platform to talk to people that you sit there and you go, God, if I had a microphone and I could speak to all these people, I would tell them this about criminal law or what that needs to be fixed. What would it be?
In the system as a whole,
Yeah.
I do think that's a really tough question, because I think there's a lot of good people on both sides that are trying to do their best to make sure the system's working as best it can. But there are issues.
Well, let me ask you a better question. If you had the governor's ear and you could sit down and he says, Vanessa, I respect you. Give me one thing about the system you would change, and he would implement it, what would it be?
I would love judges to have the discretion to waive minimum mandatories.
Can you explain what minimum mandatories are?
Yes, certain crimes I'm sure everybody has heard of the 10-20 life law, cracking down on guns and offenses that involve guns. And it's not just all guns, but certain drug trafficking offenses, certain crimes do come with it a minimum mandatory sentence, meaning that if the prosecutor or the state attorney's office files a certain charge, the minimum the court could impose would be that minimum sentence, unless the state attorney's office agrees to waive that minimum mandatory or amends the charge to something where a minimum mandatory sentence is not part of it. Judges' hands are tied. So if there's a 25-year minimum mandatory on a certain drug offense, the judge cannot go below that without the state agreeing to do that.
Which seems funny, because to me, you either lock it down and say it's minimum mandatory, nobody can change it, or if you give anybody discretion, you give it to the trier of fact and the decider of fact, who is a neutral party, not the person that's bringing the charges. That to me is...
It's funny. The most common question I get as a criminal defense attorney is, how do you defend somebody knowing they're guilty? And not all my clients are guilty. Law enforcement makes a mistake, people get charging wrong, and people do make mistakes, and it doesn't, but I have a job to do. Law enforcement has rules they have to follow, and people like me need to make sure they're following those rules and not violating people's rights, right? When it comes down to, I just lost my train of thought. This is gonna be edited, right? Wait, what was I? We were talking about minimum mandatories. Oh, I got it. Not to go on here. With the minimum mandatories, what drives me nuts about it is doing the defense side now for 10 years, everybody's set of circumstances are different. Everybody's upbringing is different. Some people, in my opinion, come from circumstances where they're set up for failure. My job is to show the judge and the prosecutors, this person is not defined by what these allegations are and what he did. There was good in them, and mitigation and rehabilitation, and this is what we can do. The minimum mandatories drive me crazy, because I think exceptions should be made under certain circumstances. Everybody's circumstances and history is different.
Very interesting. I remember when that law first passed, having a talk with a state senator from Tampa. I'm not going to say his name, long since retired. And he was so against it, and he was a Republican. He was so against it, he was Cuban. He goes, my abuela has her pill carrier with all her medications, and she takes something or somebody thinks she's shoplifting, and they go through her purse and they find it. If you have an overzealous cop, she can be charged because narcotics and trafficking amounts, because let's say she's going somewhere, so she has a week or 2 weeks of the pill carriers out of the bottle, and he goes, that's like 25 years. Yeah. And it's my grandma just on her way to Tampa Airport to go visit her sister.
And I will say this, from my experience in a circumstance like that, like you said, overzealous law enforcement, it's there. Even if they arrested dear abuela, which would be horrible, I have seen where typically you can get through to a prosecutor to see this is not the right resolution.
But my whole point on that, and my point for people at home, is that you then have to, you've seen people fall into bad situations. You get an overzealous law enforcement. Maybe he's young. Maybe, listen, I'm Greek. Maybe she's this bad-tempered, my mom. Bad-tempered Greek grandma that's going to tell that cop, you're 20 years old, the hell are you doing? And the cop gets pissed and slaps the cuffs on. And then so I don't like the fact that you're dealing with this person, and then maybe you get a younger prosecutor or whatever, and I'm not saying that they're all nice people, but catch them on a bad day, this and that, and there's no backstop to this person falling through the cracks. Or this
what happens in that circumstance? I'm going over that person's head. I will, because if somebody is not going to budge, like you said, maybe it's somebody who's new or maybe has a power trip, who knows, right? That's why they have a chain of command. That's why there are individuals you can go to. And I will say, just practicing in Pinellas County, if a case warrants going up all the way to the state attorney, I will do it if it warrants it.
But I do go back to your point that if I do agree that the judge, because you get in front of some Judge Meyer or something like that, they're going to go, oh, hold on. We were sending a boiler to prison because she was on the trip to see her. Come on, guys. It's that cooler head, no dog in the fight. Just that's what a judge is supposed to be, right? And the fact that the prosecutor has that power, but the person that we elect, because remember, judges in Pinellas and Hillsborough County are elected, the state judges that we elect don't have that power. That's mind-blowing to me. See, folks, I didn't know that.
And I'll be honest with you, part of the reason I did leave this state was because the higher up I got within the organization, the more minimum mandatories that I was dealing with, and I felt like my hands were tied, and it was frustrating, you know.
Right. Thank you so much for talking to us. It's been so enlightening. I know I'm enlightened. Why don't you tell the folks, again, who you are, where they can find you, your contact information?
Absolutely. Vanessa King. I'm lucky to be in a new office. I'm at 2510 First Avenue North in the beautiful Grand Central District in St. Petersburg. I, again, do criminal defense, personal injury law as well, and both state and federal for criminal defense. And our office number is 727-233-4233. It's just me, my paralegal, and we do have an intern right now, but my paralegal, CJ, she's great. And a small firm feel, and we'll take care of you.
Now, real quick question. What counties do you handle?
For criminal, Pinellas, Pasco, and Hillsborough. I will go out to Polk County every once in a while for the right case. Otherwise, I'll refer out there. And for personal injury cases, I have a bit of a wider reach. Central Florida. But I'll be honest, there's a home court advantage in my opinion, knowing the prosecutors, knowing the judges, and being in front of those judges all the time. People come from Orlando and Pinellas County and people are like, who is that, right? I do like to stay in the areas where I feel comfortable and where I'm familiar with the court, the judges, and the prosecutors.
And I gotta tell you folks, and I know I've mentioned it a couple times, being involved in Pinellas County trial lawyers has been a blessing to me. I know that Vanessa just got re-involved a couple years ago and has taken it by storm, going up to leadership roles and things like that. But the exposure that she gets, now I'm one of the few purely civil guys that go to Pinellas County trial lawyers. It's usually family law, criminal law. I'm a trial attorney, so I love it, but I do mostly the disability estate first party insurance. So I'm one of the really pure civil guys there. But you're sitting there on a Wednesday night, listen to a speaker, and you could have 3 state attorneys, 4 state attorneys at this table, 5 public defenders at that table, criminal law attorneys at this table, 3 judges at this table. We're being spoken to by the sheriff. We're being spoken to by 2 excellent. The panel we had a couple months ago was 2 excellent criminal attorneys, a reporter from Channel 8, and a judge talking about publicity in trials. So this connection that she has, she does know the judges, because whether it's the Clearwater Bar Association or the St. Pete Bar Association or this, they show up and you see them and you can set up these things and have a conversation with the judge. And not that it gives you an advantage, but you can say, oh, I know Judge Smudley, so this is what we're going, it's the familiarity of it.
Right.
And so you know that any judge she comes in front of in Pinellas and Hillsborough County and Pasco County, she knows. She's been in front of, unless they're brand new, of course. That's the advantage of coming with somebody like Vanessa, who's in court every day. She's in court today. She'll probably be in court tomorrow. But that's the advantage of going with somebody like her. So thank you guys so much for tuning in. Again, Bill Demas from Herman Wells. I do disability and first party insurance, dealing with homeowners insurance. I do a little bit of personal injury also, but my bailiwick is mostly disability. You can always remember, if you get denied by an insurance company, no matter what kind of insurance it is, call me. I'll be able to help you out. If you have any questions on any criminal matters, Vanessa, your person, her number is going to be up on the screen at some point in this podcast. I know I don't do that, but something more technical and magical of me will make that appear. Thank you very much. It's awesome seeing you again. And this is the Curse of Knowledge, and thank you very much for tuning in.
Thank you for having me, Bill.